Most married couples leave everything to each other and think they're done. Then the surviving spouse remarries and the kids watch half of their inheritance go to someone they barely even know. I've seen this happen dozens of times as an estate planning attorney in the Carolinas. Families torn apart over assets that could have been protected with one simple trust. In this video, I'll show you why everything to my spouse is one of the riskiest estate planning moves you can make, and what to do instead. Here's what nobody tells you about leaving everything to your spouse. You're not just trusting them, you're trusting their next spouse, their creditors, their future health crisis, their judgment 10 years from now when they're grieving and vulnerable. Here's the thing, most people don't think about this because it feels like you're planning for your spouse to betray you. That's not what this is about. This is about protecting your kids, your legacy, the wealth you spent 30 years building. Because once you're gone, you have zero control over what happens next. I've watched families lose half their inheritance because they assumed my spouse will take care of the kids. And I've watched other families protect everything with a trust that took 3 weeks to set up. Let me show you the difference. A few years ago, I had a client, we'll call her Jennifer, obviously not her real name. Jennifer came to me after her father passed away. He's a successful guy, owned a manufacturing business in South Carolina, worth about $4 million when he died. He left everything to Jennifer's mom. No trust, just a simple will that said, everything to my wife. Makes sense, right? They'd been married for 35 years, they loved each other, and they trusted each other completely. Here's what happened. Jennifer's mom was 62 when her husband died. She was devastated, lonely, and about 18 months later, she met someone in her church group. Nice guy, seemed genuine. They got married within a year. Now, Jennifer's mom had the best intentions. She told Jennifer and her brother, don't worry, everything will still go to you kids when I'm gone. But she never set up a trust, never updated her estate plan after the remarriage. 5 years later, Jennifer's mom died suddenly. Heart attack. No warning. And here's where it gets messy. Because Jennifer's mom died without a will or trust in South Carolina, the intestacy law is kicked in. And under South Carolina law, when someone dies intestate and they're married with children, the estate gets split. The surviving spouse, in this case, the new husband, gets half. The biological children split up the other half. So out of the $4 million estate, the new husband got $2 million. Jennifer and her brother split the remaining $2 million, $1 million each. Now, this wasn't some evil stepfather situation. He didn't manipulate anyone. He was actually a decent guy. But he'd been married to Jennifer's mom for 5 years. Jennifer and her brother had been their father's children for 40 plus years. And they watched $2 million, money their father spent 35 years building for them, go to someone they barely knew. They tried to fight it, spent $80,000 on attorneys, lost. Because legally, the new husband was entitled to it. He was the surviving spouse under South Carolina intestacy law. And Jennifer's dad, who spent 35 years building that wealth for his kids, had zero say in what happened. That's what happens when you leave everything to your spouse without a trust. All right, let me break down the 4 biggest risks of everything to my spouse strategy and what to do instead. Mistake number 1, you're betting your spouse won't remarry. Look, I get it. When you're happily married, the last thing you want to think about is your spouse with someone else. But statistically, it happens a lot. According to the US Census Bureau, about 30% of widows and 60% of widowers remarry. And most of them do it within the first 3 to 5 years. It's not a bad thing. I actually want people to find happiness again. But here's the problem. When your spouse remarries and then dies without proper planning, your kids don't get everything. They have to share it with the new spouse. Let me break down what happens in each state I practice in. South Carolina, if your spouse dies intestate, no will or trust. The new spouse gets 50% of the estate, your kids split the other 50. North Carolina, the new spouse gets either 1/3 or half, depending on how many children there are. Your kids get the rest. So if your spouse inherited $2 million from you, remarried, and died 10 years later without a trust, your kids could easily lose $1 million or more to someone who was never part of your plan. And here's the kicker. Even if your spouse has a will that says everything to my children, if they get remarried and don't update it, the new spouse can challenge it. In most states, spouses have a legal right to claim portion of the estate even when they're left out of the will. The fix? A spousal lifetime access trust. Instead of leaving assets outright to your spouse, you put them in a trust. Your spouse gets access to the income during their lifetime, the principal stays. They can use it for living expenses, healthcare, travel, whatever they need. But when they die, the remaining assets, the principal, go to your kids, not their new spouse, not split up with a step parent. You're not cutting your spouse off. You're just making sure your kids are protected no matter what happens. This is especially critical in blended families, which brings me to mistake number 2. Assuming your spouse will treat your kids fairly. Blended families are everywhere now. Second marriages, third marriages, kids from previous relationships. And here's the uncomfortable truth. Even with the best intentions, step parents don't always treat step kids the same as their biological children. I'm not saying your spouse is a bad person. I'm saying human nature is real. Let me give you an example. I had a client, let's call him Robert, obviously again, not his real name. He had 2 kids from his first marriage. He remarried, and his new wife had 1 kid from her previous marriage. Robert died unexpectedly at 58, left everything to his wife, no trust. His wife was great at first. She helped Robert's kids with college expenses, stayed in touch, but over time, things changed. Her own kid needed help with a down payment, then with a business loan, and then with legal fees from a divorce. By the time Robert's wife passed away 15 years later, most of the money was gone. And what was left? She had updated her will to leave everything to her biological child. Robert's kids got nothing. Now, under North Carolina intestacy law, if she had died without a will, Robert's kids would have gotten a share, but she had a will, and she was legally allowed to leave her estate to whomever she wanted. Robert's kids tried to challenge it, but here's the thing, stepchildren have 0 inheritance rights unless they've been legally adopted. So Robert's kids, who he spent 30 years providing for, got cut out completely. The fix? Separate shares and a trust. You can set up a trust that splits your estate into separate shares. 1 share for your spouse's lifetime access, 1 share that's protected for your kids from a previous marriage, 1 share for any kids you may have together. Your spouse gets support, your kids get protected. Everyone knows where they stand. No confusion, no resentment, no lawsuits. And here's the key. The assets designated for your kids stay protected no matter who your spouse marries or what happens to their judgment over time. This is exactly the type of planning we do for clients at Rankin Law Firm. If you want to explore whether an asset protection trust makes sense for your family, you can schedule a consultation with us, links below. But let me show you one more mistake people make. Mistake number 3, exposing your assets to your spouse's creditors and lawsuits. Here's something that people don't think about. When you leave assets outright to your spouse, those assets are now theirs and they're exposed to their creditors, lawsuits, and financial problems that may arise. Let's say your spouse gets sued. Maybe they cause a car accident. Maybe someone slips and falls at your house. Maybe they're a business owner and the business gets sued. If they lose, the judgment creditor can go after everything they own, including everything you left them. Or let's say your spouse needs long-term care. Nursing care homes in the Carolinas cost anywhere from $7,000 to $10,000 a month. If your spouse needs care for 5 years, that's $420,000 to almost $600,000. The assets are in their name. They have to spend them down to qualify for Medicaid. Your kid's inheritance gets wiped out paying for care. I had a client whose husband left her $1.8 million. No trust, just outright. She developed Alzheimer's at 72. Needed memory care for 8 years. By the time she passed away, there was $200,000 left. Her 3 kids split $200,000 instead of $1.8 million. The fix? An asset protection trust. When you leave assets in a properly structured trust, they're protected from creditors, lawsuits, long-term care spend downs, in many cases, bad financial decisions, and predatory financial advisors. Your spouse still has access to the money for their health, education, maintenance, and support, but it's not sitting in their name where it can be attacked. The trustee can make distributions as needed, but the principal stays protected. This is especially important if your spouse isn't great with money or if they're vulnerable to outside influence. Which brings me to the final mistake. Mistake number 4, assuming your spouse will make good decisions under pressure. When you die, your spouse is going to be grieving, emotional, overwhelmed. And that's when bad things happen. I've seen surviving spouses get talked into investments by financial advisors, lend money to family members who are never gonna pay it back, make impulsive decisions like buying a new house or a car they can't afford, get manipulated by new romantic partners, simply forget to update their estate plan after remarrying. Again, this isn't about distrust, it's about reality. People make bad decisions when they're grieving. And once the money is gone, it's gone. I had a client whose wife inherited $900,000. Within 2 years, she'd loaned $300,000 to her brother, never repaid, invested $200,000 in a friend's can't miss business opportunity, went bankrupt, and spent another $150,000 on a condo in Florida she visited twice. When she died 5 years later, there was $250,000 left. Her two kids split $125,000 each instead of $450,000 each. The fix? A trust with a co-trustee or an independent trustee. You can set up a trust where your spouse is a co-trustee along someone objective, like a trusted family member, friend, or professional trustee. Or you can name an independent trustee who manages the investments and distributions while your spouse still has access to the funds. This gives your spouse support and protection. They're not alone, and they're not making major financial decisions in the midst of a crisis. You can even include provisions that say large distributions require co-trustee approval. Investment decisions must be reviewed by a financial advisor. The trustee can step in if your spouse becomes incapacitated or remarries. It's not about control, it's about protection. And it ensures that when your spouse eventually passes away, your kids actually receive what you intended for them. Look, I've been doing this estate planning thing for a few years now. I've worked with hundreds of families in North Carolina, South Carolina, and California. And I can tell you from that experience, the families who protected their assets with trust sleep better at night. Families who didn't, they end up in my office after someone dies, trying to fix the problems that can't be fixed. I've seen kids lose half of their inheritance to a step-parent they barely know because of intestacy laws. I've seen blended families torn apart over money. I've seen estates wiped out by lawsuits and long-term care costs. In almost every case, it could have been prevented with a trust that took 3 to 4 weeks to set up. This isn't theory. This is real life. These are real families that I've worked with.